Well, good afternoon. My name's Stephen Wood. I'm the director of the Center for Law and Environment at the Allard School of Law, University of British Columbia. And I'd like to welcome you to a session of our No-Fly Zone speaker series, a speaker series in which we connect with researchers and practitioners working on environmental law related issues around the world without generating travel related greenhouse gas emissions, and also respecting COVID-19 pandemic restrictions. So I welcome you to this session. It is a talk by Dr. Natalie Oman of the University of Ontario Institute of Technology in the Legal Studies program on the recent decision of a French court, February 3rd, 2021, in the case of Notre Affaire à tous and others against France. I'm going to stop sharing the screen a moment so you can see me, and then I will hand over to Natalie. So Natalie is a professor in the legal studies program at Ontario Tech University. She has two doctoral degrees, one in law from Osgoode Hall Law School of York University in Toronto, and one in philosophy and political science from McGill University in Montreal. Dr. Oman's research reinterprets traditional sources of international legal rules to highlight their democratizing potential as avenues for inclusion for non-state political communities. Her research emphasizes the role of non-state agents as subjects and makers of particular transnational legal norms, such as the right to free, prior, and informed consent, and the responsibility to protect. In 2016, she authored a UN report that developed recommendations to prevent atrocity crimes against indigenous peoples in Latin America on behalf of the UN Office of the Special Advisors on Genocide Prevention and Responsibility to Protect. In 2019, she published a book, The Responsibility to Protect in International Law, Philosophical Investigations with Routledge. And her most recent projects include mapping the international legal sources of a right to a preserved climate system, and leading a Social Sciences and Humanities Research Council of Canada funded study on the differential impacts of remote academic teaching, which is something that is familiar to many people joining us today, I think, on equity-seeking groups. This year, we're very honored to have Natalie as a fellow and visiting scholar at the Center for Law and Environment. It's been a virtual visit more than anything else, but a true pleasure and honor to have Natalie with us this year. And she's going to be, as I said, presenting a talk about some of the legal implications of this recent French climate decision, with a particular focus on the use of arguments about general principles as sources of international law in future climate change cases. So I'm going to hand it over to Natalie, but before I do, I should just let the folks in the audience know how to engage. The preferred way for you to engage with Natalie and us today is by using the Q&A function rather than the chat. It's hard to monitor both a chat and a Q&A. So in your Zoom controls, which usually appear at the bottom of your screen, you'll find a Q&A button, and feel free to pop questions into there at any time. We won't begin answering them right away, but you can put them in there as you think of them. Natalie will speak for around 30 minutes, and then there'll be plenty of time for question, answer, and discussion. So thanks so much for joining us, Natalie, and I will turn the virtual podium over to you.
Thanks so much, Stefan. Before I begin, I'd like to express my gratitude for being able to speak to you today from the traditional, ancestral, and unceded territories of the Coast Salish peoples. I'd also like to thank the Allard Law School for hosting me as a visiting scholar this year, and the Center for Law and the Environment for Stefan and Veronica's hospitality and the invitation to speak today. Last week, the Supreme Court of Canada released its decision in the GHG Pollution Pricing Act reference case. Chief Justice Richard Wagner wrote, "The evidence clearly shows that establishing minimum national standards of GHG price stringency to reduce GHG emissions is of concern to Canada as a whole. This matter is critical to our response to an existential threat to human life in Canada and around the world." The case I'll be discussing today shares the premise of this decision. It's known as the Notre Affaire à tous case, which translates as "it's everybody's business," echoing the words of the Chief Justice. The case takes its name from one of 4 French NGOs that mounted the case. And this is Notre Affaire à tous. Notre Affaire à tous fought the case along with Greenpeace France, Oxfam France, and La Nature et l'Homme. The 4 NGOs initiated a legal proceeding against the French government in 2018 for an action for failure to act, a recours en carence fautive. The government sought to have the case dismissed in the summer of 2020, asserting that it was taking action against climate change and that the time for meeting its 2020 goals hadn't yet elapsed. The case was heard by the Paris Administrative Court on January 14th, 2021. And the plaintiffs argued in that case that the government of France has general and specific legal duties to act to address climate change. Their request of the court was that the French state be enjoined to remedy its inadequate efforts on climate change to date. And more specifically, to reduce GHG emissions to a level compatible with a 1.5 degrees Celsius rise from pre-industrial levels, and to do so in accordance with its responsibilities as an industrialized state, to adopt measures to achieve French targets for GHG emissions reductions under the Paris Agreement, and to develop renewables and energy efficiency, to undertake measures to adapt the French territory to climate change consequences, and finally to take on measures to protect citizens' lives and health. In addition to these 4 specific climate change related measures, the 4 NGOs sought symbolic compensation for moral and ecological harms in the amounts of €1. So, what were the bases for the plaintiffs' claims? Well, they sought to cite both specific and general obligations. The specific obligations that they discussed were obligations to reduce GHG emissions and to prepare for the specific impacts of climate change for France under EU and French national law. Our interest today will be, to a much greater degree, in the general obligations cited by the plaintiffs. So the general obligations that they outlined involve the French Charter for the Environment and the right to live in a healthy and ecologically balanced environment that's contained therein, the European Convention on Human Rights, Article 2, the right to life, and Article 8, the right to respect for private and family life. And finally, a general principle of law, which they described as a right to live in a preserved climate system. The court sought to the plaintiffs described these sources as together imposing on the state a general obligation to put in place practical legislative and regulatory frameworks to fight efficiently against climate change. In February of this year, the Paris Administrative Court issued its decision, and it largely followed recommendations provided by the public rapporteur at the time of the hearing. The public rapporteur is an independent judicial officer who advises the court. The decision recognized that France's inaction had caused damage from climate change, and awarded the plaintiffs the requested €1 for moral harm caused by this inaction. But it deferred its decision on whether to issue an injunction ordering the French state to adopt stronger climate measures. It gave the government 2 months to disclose steps it was taking to meet its climate targets, and that 2 months will end in about 2 weeks. As part of the decision, the court held that the French government could be held responsible for failing to meet its own climate and carbon budget goals under both EU and national law, but it rejected the argument that the government should be forced to meet particular renewable energy and energy efficiency targets. The court stated that sectoral measures can't be independently directly linked to ecological damage, or at least not as yet. And it declined to issue compensatory damages for ecological harm, finding that the plaintiffs hadn't shown that the government would be unable to repair the harm it had caused. In the decision, the court relied only on French national law. It didn't venture to directly cite the argument about general principles. Nonetheless, I think it would be a missed opportunity to ignore this source of support for the plaintiff's claim. Many of you will be familiar that general principles also figured in the famous Urgenda case. I'm probably terribly mangling that pronunciation. It's Dutch. But just to remind those who may not have thought about it for a while, the Urgenda case involved the Dutch environmental group, Urgenda, and 900 citizens seeking a declaratory judgment and injunction requiring the Dutch government to do more to address climate change. Now, in the court of first instance, the Hague Court did cite general principles in its decision to favor the plaintiffs. And that decision was later appealed and upheld by the Dutch Supreme Court. The general principles that were cited with approval by the Hague Court in that case were the precautionary principle, the principle of prevention, and sustainable development. I'd like to concentrate in the rest of my remarks on a particular subcategory of general principles to which the right to a preserved climate system and these other rights, the precautionary principle, the principle of prevention, and sustainable development all belong. This is a poorly understood subcategory of a poorly understood class of the sources of international law. General principles are one of the 5 conventionally cited sources of international law. And those other sources, of course, include international treaties, customary international law, judicial opinions, and the writing of legal scholars as subsidiary sources, along with general principles of law recognized by civilized nations. Now, I'm just going to highlight that last point. General principles of law recognized by civilized nations is the particular language used in the statute of the ICJ, Article 38.1. Now, to give you a little potted history of that statute and that list of sources of international law, these 5, this framework of 5 sources was originally identified not by those who created the statute of the International Court of Justice following the Second World War, but in fact by those members of the advisory committee to the permanent court of international justice, who were appointed following the First World War. And in 1920, more than 100 years ago now, outlined this framework of sources for the judges of the then second, I guess, International Court, the Permanent Court of International Justice, cited this framework list to act as a kind of reference for those judges in reaching their decisions. So knowing this little history helps to explain both the state-centric character of the elements of the list and also the state-centric pattern of interpretation that has dominated international jurisprudence around sources of international law since. It also helps to explain the commonplace racism of the modifying phrase that we find in the general principles element. Now, I won't dwell on this point today, but I've written about the details of the travaux préparatoires discussions among the members of that 1920 advisory committee and leaned on the persuasive analysis of them offered by legal scholar and later jurist Bin Cheng. I'll confine myself to saying that the modifying phrase of civilized nations referred in those discussions to political communities rather than states prior to its imperfect English translation. And I think it's clear that the casual racism of the term civilized to denote the idea of organized shouldn't deter us today from bending the concept of general principles to our shared purposes a century later. The phrase of civilized nations in Article 38(1)(c) is a filtering mechanism to identify general principles that have achieved jurisgenerative status. Now, the who and the how of recognition is something that is subject to our contemporary reinterpretation. I'm with American former Supreme Court judge from the 19th century, Benjamin Cardozo, on this point. He stated that rejecting the idea that we should assign a real existence to our concepts is important, because if we don't, we let them become our tyrants rather than our servants. So much for avoiding digression on this point. So during particularly the middle to late 20th century, a series of international jurists, legal scholars, and thoughtful observers identified a process for the juridical recognition of elementary considerations of humanity. The first, and perhaps one of the most prominent statements of this, following the creation of the ICJ, was in its first case, the Corfu Channel case. Elementary considerations of humanity give rise, according to this peripatetic and imperfectly developed strand of judicial and legal reasoning, they give rise to a common sense of juridical right and wrong expressed in the dictates of public conscience. Now, exemplary norms of this type are those concerned with the fragility of embodied human life on this earth, embedded in rich relationships of interchange with the animate and inanimate worlds. The classic form that these take is human rights and human rights protection norms. And this category, this particular subcategory of general principles of the Article 38(1)(c) type, was first named by Judge Tanaka of the International Court of Justice in his dissent in the Southwest Africa cases, Part 2. We later see, through decisions often involving judges from the Global South, such as Wiramantri, Cansado Trindade, and others, that human rights and human rights protection norms include at least the precautionary principle, the principle of prevention, the principle of sustainable development, the responsibility to protect principle, and the right to a preserved climate system. Now, the particular language of this latter right is still being settled. We all are familiar with cases involving discussions of a right to a healthy environment or a right to an environment of a certain quality. So the language is settling. And this is part of the process of a negotiation and recognition of core and penumbral elements of an emerging principle, general principle of international law. And this contestation is in itself acts as a filtering mechanism to determine the jurisgenerative force of sources of international law. So one of the most important features, and I won't linger on this much longer, but one of the most important features of this subcategory of general principles under Article 38(1)(c) is the democratizing potential that it contains. And this is because the possible agents of recognition of general principles are not restricted to state actors. And this was made very clear both by Judge Tanaka in 1966 and in the late 1950s by Giuseppe Sperduti, a legal scholar who later became a European Court judge. And Sperduti outlined the process, he called it the recognition process in an Italian expression, that elevated norms from having a kind of moral status because they were the focus of the attention of moral concern and expressed to the dictates of public conscience. And Tanaka was the one who focused on and emphasized the fact that norms could be elevated to the status of human rights and human rights protection norms without the assent of states. So I've written about how these general principles are identified and the evolving list of agents who can contribute to their formation and ascertainment in the responsibility to protect in international law, the book that Stefan was kind enough to mention at the beginning of this talk. But let me say briefly that this class of norms, human rights and human rights protection norms, offer an important opportunity to climate activists who choose to adopt a human rights approach to litigation that can exploit this seldom used and still coalescing subcategory of general principles. I think they can serve as a rich source of support for climate case claims against governments who fail to act to limit the effects of climate change, precisely because they have such a visceral appeal to citizens of countries all over the world who are attempting to find grounds to compel their governments to act before it's too late. And because this subcategory of human rights protection norms exemplifies the idea of protecting human life and our relationships with the environment that makes it possible for us to enjoy human rights, it is a perfectly suited class of norms to rely upon and to help to contribute to in the course of upcoming climate case litigation. One of the benefits of adopting this approach is that not only will cases of climate activists trying to achieve stronger protective measures for the environment be strengthened, but such an approach will help to advance the project of reimagining international law itself in a more democratic register. I think I'll finish there so that we have the maximum amount of time for our discussion. Thanks very much.
Thank you so much, Natalie. We will open to Q&A. As I said at the beginning, we would really appreciate if you use the Q&A function in your Zoom controls to pose questions. I will try to monitor those and pose them. And as we wait for, there's a question coming in, but as we wait for a few questions to sort of build up, can I just exercise my prerogative as the chair and ask you a question, Natalie, about general principles in climate change litigation. So what I'm wondering really is whether they practically would be confined to a kind of a supporting or interpretive role, or if you think that they could have independent legal force as a basis for liability and remedy, because we know that judges in courts around the world tend to like to rely on clearly enacted provisions of positive statute or treaty law that they or the parties can point to on paper if they can, and issues of general principle or even customary international law are often harder to pin down and harder to sort of convince judges of the exact content or status of. So do you think that the general principles can sort of have an independent life of their own, or can we expect them more to be invoked as support for the interpretation or the application of other sort of positive law norms that are before the courts?
That's a great question. I think that, as we know, many courts like to rely on statutory sources. And certainly in the first part of its decision, the Paris Administrative Court did just that. They just remained altogether silent about every argument that didn't have to do with a statutory source. But I think we know two things. One is that the Urgendis case, and I again apologize if I'm mispronouncing that. In the Urgenda case, we see the Hague Court explicitly making reference to multiple general principles of the Article 38(1)(c) type and citing multiple sources for them and using that as an important guide in reaching its decision. Now, I think because of the prominence that those principles played in that decision, and because of something that I think is new, relatively new, it's not very new, but something that is an increasingly important phenomenon, which is, and our own Supreme Court judges have talked about it, which is the network of the transnational network of judges around the world, and the fact that people like Beverly McLaughlin serve on Hong Kong courts, and this interchange, the physical interchange, but also just the interchange of ideas and the aliveness of judges around the world now to decisions being made in other jurisdictions. And I think that we see that some of these patterns of reasoning and also patterns of reliance on perhaps not traditional sources is something that is increasingly happening. And certainly we have, some of the most prominent advocates of that are judges, retired judges from our own Supreme Court. We know through the International Commission of Jurists and so on. So I'm hopeful, and I think that talking more about these things is likely to lead to, more and more reliance on these norms. Thanks.
Well, thank you. We now have a nice selection of 5 open questions, 6 now, and I'm just going to start taking them in order. If I had a better tech savvy or a tech support person with me, we could probably enable people to speak their questions, but honestly, I have no idea how to do that. So I will say them and invite Natalie to respond. I'll say names of questioners where they appear, but I have to also warn you that the last names are cut off, so I apologize in advance. The first question from Peter indicates that Vanuatu and other small island developing states have tried to have the ICJ consider an advisory opinion on climate change mitigation responsibilities. Do you think it's a worthwhile strategy, and would the French decision help to influence the advisory opinion if rendered?
I don't know the details of the Vanuatu case, so I don't know whether they've invoked general principles. Certainly the Urgenda case, and having actually directly addressed the arguments around general principles, could be of relevance if such a case were in fact accepted by the ICJ. I actually didn't know of this development. Being on research leave during a pandemic is actually surprisingly insulating. You'd think I could just be aware of everything because I have a screen in front of me and that's what everybody else is limited to. But I think that certainly there's a very long and impressive line of separate opinions and of dissents by judges. I mean, I began to list off some of the judges before, but those opinions, those very valuable opinions in cases like the Pulp Mills case and Gachikovo Nagimaros, or maybe I've got it backwards. No, it's Gachikovo Nagimaros, and a whole series of relatively recent decisions are talking about this particular subcategory of general principles in very powerful terms and linking that to the courts, the ICJ's mandate and its responsibility to draw upon global sources of legal norms and not just specifically, the kind of traditional either municipal law norms that are widely followed, or the kind of general principles of international law that are so abstracted from their origins that like good faith and that kind of thing. So I think that there's a real chance for the ICJ to recognize this. It depends on who's sitting. Like a lot of it depends upon who hears the case. That's a fairly long-winded answer for somebody who doesn't know the case.
And my understanding is that it's still at the stage of a campaign to put the request to the ICJ. I don't think that the ICJ has actually been engaged to render the advisory opinion yet. But in any case, thank you for that. The next question is from an anonymous attendee who's asking whether the principle of intergenerational equity fits in your theory. Would it fall into that subcategory of general principles, either through sustainable development or on its own? And do you see a future for the principle of intergenerational equity in human rights litigation?
It's clear when you start to think about international environmental law, it's clear that there's a double handful of principles that seem like they could be candidates to fit into this particular subcategory. It seems both obvious and very rich as a resource for these kinds of cases. And the principle of intergenerational equity seems to fit into that even the subclass of the subclass, the human rights protection norms, because human rights protection, if it's not restricted to a single generation, of course, requires this idea of equity. And so I think that there's something very, very rich and very overlooked about this idea of human rights protection norms. And of course, I give it that name. It's Judge Tanaka's term that he uses for it. And so it seems to encompass norms that are very much alive in the thinking of environmental climate activists around the world. And that certainly seems like one of the principles that there's an argument to be made. It's just not one that I've returned my attention to yet, but I'd really be happy to see arguments made to that effect.
Well, thank you. The next question is from Dana Scott, and she asks whether you can think of any particularly salient norms used in the French cases that present promising openings for climate cases in Canadian courts. And there's another question along the same lines, but I'll start you off with that one.
I think that, Dana, thank you for that question. I think this norm is promising for Canadian cases, especially given the language that the Chief Justice used in that recent decision. I think it's powerful and I think it's important. And I think that the juridical conscience that is talked about in the language of the pleadings in this case, in the Notre Affaire case, is something that is informed by the dictates of public conscience more generally. I think that this isn't, I mean, I'm terribly sorry that I've been so brief in outlining the recognition process. It's something that I've written about it extensively, and I actually have a paper that I hope will be coming out soon about this case and this process. But I think we're all familiar with the rapidity with which the norm against sexual violence in conflict, blossomed into being widely recognized as an international legal norm through the work of the International Criminal Tribunal in the former Yugoslavia. And so, although that was described by the court as at the time as a principle of customary international law, you can see that, I mean, customary international law, general principles of law are parallel sources, and many, we're familiar with many norms that have an existence, a kind of dual existence, as both customary international legal norms and treaty norms, customary international legal norms, and general principles of international law. And so I think that there's a kind of rich set of possibilities to draw on norms from the customary international legal canon as well. But just, sorry, you said, are there other norms in this case? The European Convention on Human Rights, the two sets of norms that are explicitly present in that European Convention might arguably also be described as, I mean, the right to life is obviously there, but also the second norm about the respect for private and family life, that seems something that would be a very, very easy argument to suggest that that's part of customary international law, and that could bolster a case in Canadian courts as well. So thanks, Dana. Sorry for that. It was a bit rambling.
And Natalie, I think one point that came out in your earlier remarks that might be relevant here, maybe you could just clarify. Whereas customary international law is based on state practice and opinio juris, and therefore involves a degree of acceptance by states, you were pointing out earlier that general principles can emerge without positive, acts of acceptance by states. Do you see that as a significant difference or a significant advantage for folks who want to rely on general principles?
Obviously, that's a revolutionary difference, and Judge Tanaka was the first, very august legal figure who explicitly articulated that difference. And I think that because the state centrism of conventional understandings of international legal sources and their interpretation really limits what non-state communities can do, and what citizens who are sort of captives of governments that won't act to try to mitigate climate change, the position that they're in. I think that it's incredibly important at a moment like this to delve into and to develop the potential for a transformation of the structure and practices of international jurisprudence by taking advantage of this feature. And just to be clear, I mean, one of the things that comes up often when you start thinking about, well, if states aren't the arbiters of what is or is not a general principle, then who is? And I think that when you look into this more carefully, you realize that relevant interpretive communities are actually the arbiters of what is and is not accepted as a general principle. And that sounds very arbitrary and dangerous in the sense that, well, maybe that's just going to bolster the existing power structure, and non-state communities aren't going to have any more hope of making a difference than they did previously. But I think that that's not true. I think if we actually look at the way that international legal norms emerge, it's always through this kind of hermeneutic exchange among interpretive communities. And what we can push, and what this case begins to push, just in a very small way, is the membership in those interpretive communities. Which classes of arguments, which argumentative gambits start to be recognized as acceptable in this interpretive dialogue. And you certainly see that in the Inter-American system, the Inter-American Court of Human Rights, and the Commission, they're both very much more open to non-state originating arguments about international legal principles. And certainly that's a very rich place to look if you're trying to develop these kinds of arguments.
Thanks so much. And sorry for butting in, folks. Just so people know, we have a question coming from Julia Rowe, and then after that, Maya Acevedo, Marian Peters, and Natasha Affolter, and then a few more after that. Julia's question is about what do you see as the potential of using general principles in climate change litigation in Canada, where there's a disinclination to recognize positive rights or obligations on government, as seen in the recent decision dismissing the claim in the LaRose children's climate case. So could general principles help overcome those obstacles?
I think it's a process, and I mean the LaRose case had a very specific set of circumstances. It was framed in a particular way. I think that it seems to me that Canadian courts are quite attentive to the developments in international legal decisions, and I think that the Urgenda case and now this Notre Affaire case, and I mean there's a whole truckload of these cases that are pending or are just being decided. There's very important stuff is happening in Brazil as well. And I think that it's true that Canadian courts have historically not been keen to look to sources of international law that are not positive in their character. But I also think that, I mean, the courts' struggles over the last several decades with Indigenous rights have been one of the impetuses that have basically compelled them to start to be aware that the insularity of some of these decisions about fundamental rights that the Canadian courts have relied upon. I mean, now they're in a terrible state because, of course, there's the whole Canadian reliance on their understanding of Indigenous rights, and then all of a sudden we have UNDRIP, and British Columbia merrily taking up a commitment to UNDRIP in its legislation, but it's not really consistent with the Supreme Court of Canada's position on Indigenous rights. And I think that those kinds of very awkward and embarrassing evidences of insularity to international legal wins are something that the Supreme Court's going to want to avoid. And so I think there's hope. I think that maybe we should adopt specific civil rights litigation alongside these kinds of cases, because that does seem to be, the push from both directions seems to be quite productive where that's being done. Thanks, Doug.
I like your analogy of international legal winds, thinking of them as a wind that's blowing. The next question is from Maya Acevedo, who's asking about your book. Could you expand briefly on the scope and the methodology of the book, Responsibility to Protect in International Law, Philosophical Investigations? So that will take us on a tangent, but I wonder if you have something briefly to say about that as a little plug for your book.
Okay, I'll try to make it as much about what I talked about today as possible. And it is about what I talked about today. So I talked about the very contentious character of the normativity of the responsibility to protect, which had a lot of attention in the early 2000s, and then the unfortunate coincidence of its release date, which was, I think, several days after 9/11 occurred, and a big shift in the international discourse on security, and human security versus national security suddenly was not the flavor of the month. And also the difficulty that the United Nations Secretariat had in I'm trying to think of what the kindest term would be, in trying to elicit concrete support across a very diverse group of national blocs at the United Nations. This led to, at one point, an outright denial by the special advisor to the Secretary General of the United Nations that the responsibility to protect had any international legal status at all. Now that's been softened since, and they pulled it back. But I used this debate over the responsibility to protect to try to talk about the way in which core and penumbral meanings of international legal norms are negotiated and can change over time, and how misleading it is to speak of, the interpretation of one of these crystallizing and evolving norms in a dynamic international transnational context. So I delved into, exactly how general principles, and particularly general principles of this subcategory, are formulated and evolve in quite a lot of depth because of its relevance to that particular example of that subcategory.
Well, thanks for that brief description and pitch. Natalie, the next question is from Marian Peters, and if I knew how to unmute your mic, Marian, you'd be able to tell us about the pronunciation of Urgenda. Marian Minesma, another Marian, has said to me in a very typically pragmatic Dutch approach, just give it an English pronunciation when you're speaking English, Urgenda when you're speaking English, and something like Urgenda when you're speaking Dutch. But Marian says she's understood that the French case of the century, Notre Affaire à tous, is about compliance with existing legal obligations, while the Dutch Urgenda case is peculiar since it's not about compliance with law, but about a claim about doing more than EU law required. Shouldn't that difference be stressed? And given the difference, are the general principles equally relevant for both situations?
That's a great question. And thank you for the tip on pronunciation, and I'm sorry that we can't actually hear you ourselves, but also for the really good question. I think that it's very clear. I mean, Urgenda, there, see, now it sounds like I'm speaking Spanish. The Dutch case is, again, as you say, distinguished by the fact that it's asking the court to require the state to do more. And it's requiring the state to do more, partly in recognition of the existence of this right to a preserved climate system. It's asking the court to do more. Now I'm putting words in the mouth of the plaintiffs. It's asking the court to do more in recognition of a cluster of human rights protection norms that are general principles and that aim for the same sort of protective result that the particular general principle cited in the French case does. Now, the French case, as you say, is, although if you read the detail of the plaintiff's pleadings, they do actually make a very interesting case for regarding the right to a preserved climate system as a general principle. I think it adds a lot to the texture of the case, but it does focus on statute, and they're looking for a statutory declaration. They're looking for a declaration that the French government is failing to meet its own climate targets under the Paris Agreement, more or less. They're not asking for more. It's implied, but they're not asking for more. And I think that one of the things that the general principles arguments can be very valuable for is precisely to set the bar higher, because they flow from this idea of the vulnerability of human life. And they don't rely upon some kind of argument about a universal set of shared norms. It's not about whether legal frameworks are identical. It's about a shared vulnerability to suffering that's just a phenomenological reality for human beings. And so they lend themselves to use in lots of different legal jurisdictions and lots of different settings. I'll stop there. Thanks.
Thanks so much. And thanks, Marian, for your question. We have 3 more questions in the queue, and I think if we answer those, we will have done very well. So I would say that's our goal for today, and then we will draw things to a close. The next question is from Natasha Affolter here at Allard at UBC, who says, thanks for your talk, and asks to what degree you think judicial aversion to general principles is part of a general reluctance to engage with international law. Based on your R2P, responsibility to protect work, do you think there might be more or less openness to general principles in the climate context as compared to the human rights context?
That's interesting. I focus probably to a slightly unjustifiable degree on these extremely powerful separate opinions and dissents by members of the ICJ that typically are, many of them involve environmental issues. So I think now of course, they're looking at these environmental questions through a human rights lens. But I think that, because the context in which these decisions are being made is changing every day for the worse, my feeling is, based on the language of the, again, I'm going to mangle it, Urquenda case, and also because of the support offered by the human rights frameworks of both the inter-American system and the European system, most notably, I think that the potential to use these general principles arguments in climate cases is greater than it would be in straight human rights cases. I think that there's a kind of intuitive appeal that we see reflected again in the words of Chief Justice Wagner in the decision last week. It's impossible to deny. You can't enjoy any other human rights if the environment is destroyed. And so it makes it relatively simple. I know that's a kind of gut reaction rather than a technical legal argument, but thanks, Natasha.
The last two questions are from an anonymous attendee. I'm not sure if it's the same one or different ones, but the first of the questions brings us back to the Canadian context again, asking whether you can draw a connection about how this topic fits with the Nevson and Araya decision of the Supreme Court of Canada in 2020, where the Supreme Court held that, and this is a quote, customary international law is part of Canada's common law, and it means that it must be treated with the same respect as any other law, end quote. How can Canadian courts use general principles of international law in light of the Nevson case?
I almost talked about the Nevson case. I just thought, because it was at the CLE, it was more appropriate to use the Notre Affaire, but that was the talk I was preparing. I think it's an enormously encouraging decision. And I think that it's very difficult to see how the court can argue that general principles are not taken up in domestic law in precisely the same way as customary international legal rules. What's to choose? They're both sources of international law. So I think that's a wonderful example, and I'm now kicking myself for not having mentioned it earlier, but I'm really glad that you brought it up. So thank you to the anonymous questioner. And yes, I think certainly the argument can be made, and we just it hasn't been successfully made yet before the court, but certainly it would seem to be striking inconsistency if they don't adopt the same approach to general principles that they have to customary international law in such similar circumstances where it's around human rights.
Do you know, by the way, Natalie, whether the Supreme Court of Canada has ever engaged explicitly with general principles as opposed to customary international law? Deliberately and explicitly on their own terms, saying we are looking at this as a general principle of law recognized by civilized nations as a potential source of international law in Canadian courts.
I'm thinking about conversations I've had with Ian Binney but they were after he retired, and I'm not sure. So I'm thinking about his own reasoning, which I know he and certainly his colleagues are alive to these norms and are attending to the way that they're impacting international law. And he's been very activist through the International Commission of Jurists and some of the cases that he's helped to support. I can't think of a case off the top of my head. And that is certainly, a job that I should hire somebody soon to help me to undertake. But I don't know of a particular case. I'm just hoping that by talking about this a lot, there will be one soon.
And I think a lot of Canadian judges and lawyers are not versed enough in international law and sources of international law to sort of grapple. I was going to say properly, but that's not the right word. But to grapple, in an intelligent way with these issues. I'm not sure that the courts would appreciate that distinction. I think of Justice Leroux Dubé's references to the subsidiarity principle in the spray tech case on, local bans on cosmetic uses of pesticides. I think of things that Justice Bastarache wrote about sort of the use and misuse of international law. Maybe it's an opportunity for some judicial education.
That sounds right to me. And I think that, if there were ever a moment when the court would be open to that in a particular context of a climate change case, it seems like it's now. So that's a great suggestion.
Well, the final question from anonymous attendee is, in the Urgenda case, the Court of Appeal stressed that even if there was no complete scientific certainty regarding the effectiveness of the reduction order, it doesn't entitle the state to refrain from taking further measures. But who should order that? What if the French government don't act in accordance with the court decision in 2 months?
Well, I'm not sure if I get let me answer what I think is the sense of your question. At the moment, as far as I understand, the French government is planning to comply. It's a specific order to particular ministries, and they are gathering the data as far as I know. Whether they'll meet the deadline, I don't know. But I think that the intention is certainly to comply with the court's order. Now, what happens next if the court orders specific remedial measures because it deems the measures being taken to be inadequate? That's the question, right? And I think that maybe that's what you're getting at. All of us are familiar with the problem of having courts get into public policy making and start to make highly technical recommendations or requirements to governments about matters that aren't really in the purview of courts. I think that part of the most important impact of these kinds of decisions is to emphasize that political decisions should be made by political actors in a responsible way. It's very much, as we all know from Canadian cases where Aboriginal rights are at stake, the courts are always, doing the kind of minimum that they must, and then emphasizing that this should be a political process of determination and policy making. And I think that something very similar will happen in this case. I don't know, but anyway, I'll stop because I think we're over time.
Well, thank you very much for your answers to those questions. Thanks to all of the attendees for the questions and for joining us. I wanted to also say, I don't know if you noticed, Natalie, but I appreciated the delightful Zoom bombing by Black and White Cat, who walked in and then later out, and then just a moment ago walked back in behind your shoulder. So that was nice to see.
I didn't know if anybody else had noticed.
Oh no, it's a lovely kind of Zoom bombing, one that we welcome. So thanks so much again. This is the final event in our no-fly zone series for this academic year. So thanks to everybody who has joined us for more than one of these sessions, and I hope we see you in the next academic year for another lineup of no-fly zone virtual speaker series. And if we were able, we could all join in a round of applause, but I'll do it. Thank you so much, Natalie. And for those who are interested, a recording of this session will be available on the website of the Center for Law and Environment in due course, if you want to refer people to the talk to take a look at what Natalie had to say. So thank you once again, everybody, and appreciate your time.
Thanks, Stefan, and thank you for the questions. Bye-bye.